Good morning, everyone, and welcome to AICC's first COVID call of the new school year. I want to welcome you. I am Taryn Pyle, and I will be hosting this call today. If you are new to these calls, I want to welcome you. AICC, the Independent Packaging Association, is dedicated to uniting and celebrating the success of inspired independent packaging companies through education and networking opportunities, in person, online, and in print. If you want to learn more about all that AICC offers members, you can visit our website at aiccbox.org or give any staff member a call. One of our most active benefits is our free e-learning courses available to all member companies and their employees. You can find information on the courses at our packaging school under the Learn tab on our website. Additionally, this year we're offering an all-access pass, which gives you and all employees access to all of our webinars this year, currently at 50 in production, sales, customer service, HR, and leadership, and more. To find out more, send me a note or check out the top of the calendar on our website under the Learn tab. It's a $12,000 value. We have a few housekeeping details before we get started. The call today will be 60 minutes long. A recording will be posted on Monday under the COVID section of our website. I do want you to know that on these calls you can hear us right now, but we can't hear you. We do this because we are recording the session. If you have a question, you can raise your hand using the hand feature on your dashboard. Or if you are on the phone, you can press *9 and this will raise your hand as well. You can post comments and questions also in the chat area located at the bottom of your screen. So just a little overview of Zoom for those of you who may not have been with us this past summer. Take your mouse and move down to the bottom and a bar will pop up. And on that bar to the left, you'll see mute and stop or start video. This is how you can show us your face on the screen, and we'd love to have you join us. To the right, you'll see participants. If you click on this and open it up, you will see at the very bottom the opportunity to raise your hand or lower your hand. This is how you can raise your hand to ask a question or make a comment. Further over, there's a chat feature, and you can also post any questions you have here, as well if there's any suggested documents or notes that you want to make to other people, you can post it in the chat area. And finally, if we can just for a minute, just so that I know the chat's working and you know how to use it, if you can go in there and post it in the chat, tell me one thing that's been good for you during the COVID crisis. With technology, there is always a possibility of losing a connection, sound, or viewing of the presentation. AICC will keep you posted on the status of any problems using the chat feature. If you get a dial tone or disconnected from the site, you will need to call back in. This would indicate that there's a connection problem on your end. As we begin, please remember, AICC is an international trade association, and as such, members are bound to uphold the letter and spirit of all applicable competition and antitrust laws, including those of the U.S. and Canada. During this meeting, there will be no discussion allowed concerning prices, customer or market allocations, specific accounts, discounts, terms, and all other matters prohibited by law. And I now want to turn the mic over to our president, Mike D'Angelo. Mike.
Thank you, Taryn, and good morning, everybody. Welcome. Hope you're at the tail end of what's been a good week. Incredibly, if you haven't checked your calendar, we were all supposed to be in Orlando this week at Supercore Expo and at the AICC National Meeting. Obviously, we are not. But it's still good to get together with you. We began these weekly COVID video conferences back in March when the pandemic first arrived on our doorstep. We took the month of August off to just kind of regenerate, and we're kind of launching this one as a let's figure out, as Christine's title is, what's now and what's next. But although we've been dark during the month of August, and this is actually going to be the last AICC COVID video conference, and I'll get to that in a moment. We've been very busy on programming. We will be commencing, instead of these COVID video conferences, we'll be commencing in November. The Converters Think Tank. This will be a panel of box makers that will speak not just to how they're dealing with COVID and the pandemic and regulations as we know them, but also business conditions, supply chains, etc. We think it'll be a more broad experience and a more inclusive experience for all levels of your employees in the plants and with our suppliers. We've also begun the AICC webinar series. We have more than 50 webinars that commenced starting last week and going through August of 21. This is to beef up the programming that you have accessibility to. AICC has launched an all-access pass to make participation easy and cost low. Virginia put a link up in the chat box for you to investigate that. You can also check it out at the AICC website. At the AICC website, we have continued what's now a weekly COVID update page. There is a lot of relevant information there, not just about some of the items that Christine is going to address today, but other governmental regulations, as well as helpful tips to keep your employees safe and to keep them motivated. I recommend, if you're not at least accessing it once a week, someone who's responsible in your organizations for human resources does so. I mentioned we're supposed to be in Orlando. We also kicked off, because we're not, the SuperCore Tech Talks. They began on Tuesday, and there were 4 suppliers on Tuesday, 5 suppliers on Thursday. If you're not keeping up with those, the next round of Tech Talks will commence on September 29th. They're going to be every other week on Tuesdays and Thursdays running through November. This is a good way for you to keep abreast of what's new, what's coming in the industry, what you would have seen in Orlando, and what you will see when SuperCore commences in August of 21. So let's get to the reason why we're here, because we're kind of coming full circle. We started in March talking about COVID-19. We're going to start our September series with COVID-19, and we're blessed to have Christine Walters of FiveL with us. Christine is no stranger to AICC members. She has spoken at several summits and conferences and has been a valuable partner to AICC, not just through COVID, but through navigating any and all human resources issues that members have faced over the years. Christine has more than 25 years combined experience in management, human resources administration, employment law, practice, and teaching. She's received several awards and has testified before the United States Congress and state legislative committees and administrative agencies on employment issues. She's an author. Her book, From Hello to Goodbye, Proactive Tips for Maintaining Positive Employee Relations, has been one of the Society for Human Resource Management's Great 8 bestsellers for 5 years in a row. Today, Christine works as an independent consultant, providing proactive human resources and employment law consulting services and training programs, doing business as the FiveL company. Christine is licensed to practice law in the state of Maryland, and she joins us today to present to us and to discuss with you what's now and what's next. Christine, please.
Mike, thanks very, very much for that introduction. Thanks to Taryn for all her help and support behind the scenes, and thanks to everybody joining the live presentation right now and those that might be listening to the recorded version. So in the time we have together, what we'll cover is, and I really tried to focus on your industry. So what are some COVID-19, CDC, and other agency guidance related to manufacturers? So we're going to fairly quickly run through, I think, kind of the first half focus on manufacturers, and then do a quick timeline of what have all the updates, modifications, reinterpretations been kind of May, June, July, August, September, to where we are now, and then wrap up with what might be on the horizon. So quick historical recap, if you will. March 18th, Families First Coronavirus Response Act is enacted. April 1st, it took effect. Same day, Department of Labor pushed out regulations. So a lot of times, you know, laws come out and then we wait and we wait and we wait, and the regulations tell us from the federal agency that's designated to enforce the law how we're supposed to do it. So the fact that they came out the same day, DOL did a quick job. I think they did a fairly decent job. However, like so many things, there are a few things that weren't clear. So 9 days later, they pushed out some amendments to those regulations. April the 14th, the state of New York, little asterisk, I think your handout says state on New York, state of New York filed a lawsuit and said, Department of Labor, you exceeded your authority when you published those regulations. Goes through and on August the 3rd, New York judge agreed with at least the state of New York in part and said 4 provisions of those regulations were invalid. And September the 11th, Department of Labor modified their frequently asked questions on their website. 5 days later, which was this past Wednesday, Department of Labor, because I was wondering ever since the August 3rd decision from the court, was the Department of Labor going to file an appeal? Well, it looks like the answer is no. They just changed their regulations. So we're going to do kind of a quick run through of some of the key highlights, I think, again, most pertinent perhaps to your industry. I want to share with you, it won't work on the screen right now as you're looking, but if you download and save the PDF copy of the handout, when you open it up on your computer or your laptop, everywhere you see the greeny blue, if you will, color, those are hot links that I included. And let me just get a little line here. There we go. So right there, for example, you can just click on that. Again, once you save the PDF and then reopen it, you can click on those. I wanted to provide you as many resources as I could for all the things that we're going to do, talk about, because it's going to be pretty much a quick flyby on these. So starting in May, CDC issued guidance for manufacturers. Let me close that out. I don't know if you all saw that or not. Guidance for manufacturers and their employees. So one of the first things they talked about was employers, you should develop a communication plan for your staff. And they give some examples. And I figure if a federal agency is going to give us some resources, why reinvent the wheel? So you don't have to use these, you may use them. And so they give examples of, for, some part of your control plan, you don't want workers, and like this is a surprise, we all know this, you don't want workers working in a distance that's less than 6 feet. That's the first one. Second, 6 feet apart is good. They talk about physical barriers, using plexiglass between workstations, good, and give some other examples there of using physical barriers. If you have, now this is kind of location specific, I think. Some employers have, for example, some states offer a tax credit if an employer offers employees carpooling. So if you're aware of employees that carpool, you might want to put this poster up in your workplace or just send this out to your employees, tips for them to help prevent the spread of COVID-19 as they are carpooling with others. In May then, we had same thing, the guidance continued and said after the communication plan, employers, you should develop both engineering and administrative controls. Again, they gave examples. So for manufacturing facilities specifically, I'm going to start over here. Whoops, sorry about that. Oh, there we go. Keep employees, so I know it's small and I apologize. I'm going to start on the upper left, go down, and then just quick run through. Let me get rid of that little check mark there. Eraser, and we get rid of that. Okay, good. So upper left talks about distancing employees in your workspace. So again, your physical distancing. Second bullet talks about frequency, increasing the frequency that you're cleaning workspaces and workstations. Screening employees. Think about, do you want to screen? Yes or no? If you screen, how you screen, when you screen, and where you screen. So for example, before people even come in the building, if they're going to come in the building, let's face it, cold weather is coming, maybe just as soon as they come in, there's a table at the lobby. Are you going to take temperatures or have them answer a questionnaire? Hand washing, making sure if you can provide, not that you have to, but if you can provide hand sanitizer, encouraging employees to wash their hands, giving employees tips about reducing the spread, upper right. If an employee has symptoms or they're sick, tell employees, we want you to stay home. I don't want you to come in here and potentially spread the virus. Second bullet down on the right is telling employees, reminding them about physical distancing rules. The third bullet down on the right talks about face coverings. And right now, watch your states. Make sure you're keeping up with your governor's executive order and or state law, because some states, a lot of them say we have to wear face coverings. Some are saying the employer has to provide it. Last I checked, New York, Michigan, I think it's New Jersey and Rhode Island. Some of those, though, are industry specific. So again, talk to your company's legal counsel. If I didn't say that in the beginning, I'm going to say it now. This program does not constitute the rendering of legal advice. Please, please, please talk to your company's legal counsel about what are the requirements under our state's governor's executive order, as well as our state's General Assembly, any new laws that might have come out. And then next to last bullet on the right-hand side, again, talking about PPEs. And right now, face coverings are not considered PPEs. So make sure if you have employees in positions that under OSHA require a PPE, make sure you're providing those. Face coverings generally not considered a PPE. And then the last bullet on the right, just about having an emergency operational plan. You know, what are you going to do, for example, if an employee in your workspace does test positive? And then after you do communication plan, engineering controls, administrative controls, and then educate and train your employees and the supervisors about how they can help reduce the spread. And so the guidance said the training should be, one, easy to understand, provided in appropriate language or languages. So if you have an employee population, for example, that is predominantly Spanish speaking, you want to provide the training in that language at the appropriate literacy level, include accurate and timely information. And that's the challenge, I think, because this stuff keeps changing. So what's accurate and timely training today might not be 2 weeks from now. So it's tough to stay ahead of that. And then they talk about some examples, talking to employees about what are the signs and symptoms, what are the risks, how do you reduce the spread, and how do employees protect themselves. Again, hand washing practices. That link will take you, again, CDC and others are providing posters. And throughout this, and I think I'm going to touch on this later, a lot of the guidance is just that it's guidance. So when you read the word should, it's not mandatory. However, I'm inclined when a federal agency tells us what they think we should do, I want to do it because you may have heard about lots of lawsuits being filed about employers. Oh, my employer was negligent. I caught COVID-19 at work and I think my employer was negligent. So I think it could, again, talk to your company's legal counsel. If you should ever need to make a defense, you'll be able to say, absolutely not. We followed the guidance. We knew it wasn't mandatory. I'm afraid if there's guidance out there and we don't follow it, is somebody going to infer that, well, you decided you weren't going to do that, so you were negligent. I don't want anybody to be able to say that. Cough and sneeze etiquette, you know, in the crook of your elbow. I always giggle when I see or read that we should cough in our elbow, and I can't quite get over to that side of it, but we know that they mean in the crook of your elbow and other infection control procedures. So again, I didn't put the posters in the handout, but just so you can see some examples of what posters are being put out there that, again, you can put in your workplace to help communicate to employees and talk to them about what they can do, what they should do, hand washing, that sort of thing. When do I wash? How do I wash? Kind of basic stuff. However, you know, again, federal agency is suggesting we might want to do that. This I thought was interesting, saying OSHA has instructed its compliance, safety, and health officers to evaluate whether an employer has made a good faith effort. So they're going to look at, you know, if an issue comes up, they're going to look and say, show us what you've done, when you did it, where you did it, and determine whether they think you made a good faith effort to comply with applicable OSHA standards. And in situations where compliance was not possible, given the ongoing pandemic, to ensure that employees were not exposed to hazards from tasks, processes, or equipment for which they were not prepared or trained. So I call that a clue. If an issue comes up, that's what they're gonna look for. And so I want to be able to say, I can definitely show you good faith. No problems there. And part of the control plan, again, for manufacturers, considers cleaning and disinfecting workstations, equipment, machinery. Are you screening and monitoring workers? If so, again, how you're doing it, when you're doing it, where you're doing it. There's a footnote here that I find curious, and I would suggest you might want to talk to your company's safety officer, attorney, somebody that's fairly well versed in the application of OSHA regulations for manufacturers, because a footnote on screening says employers should evaluate the burdens and benefits of recording workers' temperatures and asking them to complete written questionnaires. That part I get from my perspective, which is more on the ADA side, Americans with Disabilities Act. We know medical information is confidential, can't put it in an employee's file. You have to keep it separate from, so you've got to maintain those records separately. What I thought was interesting is this is from an OSHA standpoint, says these types of written products become, didn't say may become, it says they become records that must be retained for the duration of the worker's employment plus 30 years. And so under OSHA, there's record keeping retention requirements. What struck me was if you're gathering that information, for example, my husband he works in a hospital, goes in every morning at the time clock, which is just outside the lobby. He has to answer 3 questions every morning. If he answered yes, have you been exposed to someone who had COVID? If he answers yes, it just strikes me as odd that OSHA is saying this becomes an OSHA-related record when, wait a minute, we don't know yet if it's a work-related exposure or not. We don't know who he was exposed to. We're talking about a coworker or somebody at a party the past weekend. So talk to your safety officer about the interpretation of that and whether you do or do not need to retain those records, where, how long, etc. And then if an employee has been exposed but is asymptomatic, no symptoms, can you let the employee continue to work? So Taryn, if you don't mind, if you can open up, that's our first polling question. What do you all think? If an employee says, yes, I have been exposed, but I don't have any symptoms, can you let that employee continue to work? What do you think? Yes, no, or I'm not sure. Yes, no, or I'm not sure.
We're getting some answers. Right now it's going at 76% is at no, 14% is yes, I'm not sure is at 9%. 75% is no. Averaging, most people are saying no.
And so I'm humming the Jeopardy music to myself. Taryn, you tell me when you want to.
I think you've got pretty much, you got 27 people responded out of 39, so I think you've got a pretty good response. Can you see the poll?
I can, yeah. Okay. And I recognize not everybody may be at a keyboard. Some of you might be on your cell phone or not able. So yeah, if you want to close that out, 18% said yes, 76% said no. And I appreciate, and just so you all know, if you're shy about answering, I can't see who answered, I just see numbers. So 7% said, I'm not sure, and I appreciate your candor. This might be a new fun fact for the day, because 76% of you said no, and actually, whoops, I'm sorry, I'm supposed to share the results. And so the answer to this is yes, we'll say a conditional yes. And this was new guidance that came out, I think we're still in the month of May, and said that, and we're going to see this in a couple of slides from now, so hold that thought. And the answer was, so long as they're asymptomatic, you can permit the person to work. So again, the question was, I said I was exposed, but I'm asymptomatic. So hold that thought, and we'll do that slide in a few minutes. Now, what about somebody who's symptomatic? So I have an employee that's either exhibiting symptoms related to COVID, and you can get that list on the CDC website, or an employee has told me that they've tested positive. Need to separate, as soon as you hear that, separate the employee from others, send them home. That's, I think, probably going to be kind of simultaneous, but maybe you want to ask some questions. Make sure you are physically distanced as well. If it's a positive test result, you should, CDC says, inform coworkers who may have been exposed. You may not disclose the employee's name to those coworkers. Now, if it's a fairly small facility or unit and, you know, there's 8 of us working together and one person's missing, I think, are the employees going to figure out who it is? Probably yes. Just make sure you're not the one that discloses that name. There is another interpretation or rule that came out from the EEOC that said, well, what if, and I'm not sure this is applicable for y'all, what if I have my employees, I send my employees to a client site. So maybe they're working on equipment or on a manufacturing line at a customer's location, and my employee comes back and says, I've tested positive. In that instance, where we send one of our employees to work at like if we're a contractor and we send the employee to work at the customer or the client site, in that instance, you are allowed to disclose the name of the employee to that client company or employer there so they can conduct contact tracing. You may also disclose the name of the employee to your local health department. And I definitely recommend that. When you have these questions about, you know, what do we do? Who do we tell? What do we say? What do we not say? First thing I would do is pick up, call your local health department, give them the name of the employee, you know, say this morning, 8 o'clock, employee just told us, we separated, we sent the employee home. What do you recommend? What, you know, what are the things we do now? And then we'll ask you a bunch of questions. What does a person do? To whom were they exposed in the workplace? And some of those things. Make sure you promptly disinfect the workstation where that employee worked. And again, contacting the local health department. And Taryn, if questions are coming in as we're going through, feel free to say, hey, Christine, well, this question just came in. So you all feel free to ask questions along the way.
Okay.
Then we jump to July. For me, RTW, return to work. So questions about, okay, the employee either had symptoms, so we told them to stay home, or they had a positive COVID-19 test, and we told them to stay home. On July 20th, that guidance changed. The guidance used to be have the person tested, and then they could come back to work after 72 hours had passed with no fever, and that's no fever without taking any fever-reducing medication like aspirin. On July 20th, CDC changed that recommendation, and they're now saying a test-based strategy isn't recommended by them any longer. And instead of 72 hours, they dropped it down to 24 hours. Now, for individuals that never developed symptoms, they were asymptomatic, CDC now says as of July 20th, isolation and other precautions can be discontinued 10 days after the date of their first positive test. Now, it kind of struck me, again, all this stuff might change. I don't think we know for sure that once a person gets COVID and they've recovered, that they cannot get it again. So I'm wondering on the horizon if they might modify that to say 10 days after any positive test or after recovery from the first. So we'll just stay tuned there. I think as soon as we find out whether somebody can get it again, that guidance might change. Then we have a whole flurry. I'm not going to go through all these. I'm just going to point out, I think, a couple of things here. And they would be, let's see, on the second bullet. So the EEOC all along the way has been updating. It has a page. They're up to, last I checked, which was Wednesday, 103 frequently asked questions. So all sorts of questions, you can get answers there. IRS, definitely talk to your accountant, tax attorney, whoever does your payroll. IRS published guidance on, I'm curious, Taryn, maybe you can see if we can ask folks to raise their hand. Do any of you have paid leave donation programs for your employees?
You can raise your hand by clicking on the participant list and at the very bottom, clicking raise hand. If you're on the phone, you can do *9, or you can post in the chat either yes or no.
I'm just curious if anybody's doing that. I don't find they're very popular, but some employers already had those available.
Can you repeat the question again, Christine?
Sure. Do any of you have a paid leave donation program? In my experience, they first became popular. Remember Hurricane Katrina? I don't know how many years ago that was, 15, 10? They became very popular, and I think a lot of employers kept them.
We've got we had one yes, and then we have 3 no's in the chat.
Okay. So if you do, or if you were thinking about it, absolutely fine. There are some tax implications on that. And so you can, again, when you download the slides, just click on that link in that second bullet, and that will take you to the IRS guidance. June 16th, you may know there is in place now a Form I-9. You know, when you hire somebody and they have to complete the Form I-9 and you have to see the original documents. How do I see the original documents when so many people are remote? There is a possibility that you can view remote documents by email, by fax, or by video. That rule only applies if 100% of your workforce is remote. In manufacturing, I suspect that may not be the case for anyone, but that rule's still available.
Christine?
Uh-huh.
Steve had a question from the audience about the paid leave. Can we go back to that for a minute?
Sure, absolutely.
Steve?
Yeah, I can you please explain the paid leave donation program?
Sure, absolutely.
You only had a few people respond. Perhaps others don't really understand what it is.
Oh, thanks for that. So yes, what some employers do, it's developed and implemented different ways, but maybe an easy explanation. So let's say I have 100 hours of paid leave available, and I know somebody that just fell on a hardship. You know, there's a hurricane, there's a tornado, they're terminally ill, and what I could be able to do under a paid leave donation program is say, I want to donate some of my paid leave either directly to that employee, which is not the most popular, or into this pool. So the employer maintains one bank of donated paid leave. So any employees can donate leave into that. And then if an employee falls on hardship, they can kind of apply to get some of that donated paid leave to help them out while they're off from work due to, you know, a disaster or an emergency, something like that. So there's lots of questions, you know, if you make 60,000 and somebody else makes 30 and somebody else makes this, and then I get the leave, you know, how is it donated? How am I taxed on that as a donor or a recipient? But that's kind of it in a nutshell. Thanks for that question, Steve. June 18th, OSHA issued guidance clarifying face coverings. In short, what they said was, 1, they're not PPEs. 2, employers do not have to provide them. That's what OSHA said. Again, please check your state laws, because some states, for some industries, some are covering all employers, are saying employers do have to provide the face covering. So double check your state law there. June 26, if you've been administering the Emergency Family and Medical Leave Act under the FFCRA, and so how do I do this in a nutshell? So the Emergency Family Medical Leave, where an employee says, I can't work because either my child's daycare provider is closed for a COVID-19 related reason, or the school is closed for a COVID-19 related reason. I need time off from work. That would qualify for paid leave under the Emergency Family Medical Leave Act. Now, you know, we're in September and schools are opening in all different ways, right? Some are 100% remote learning. Some are giving parents the option to send their students in person or attend remote. And some schools are in person, but on a staggered schedule, right? So list A students come to school in week 1, Monday, Wednesday, Friday, and the next week they come in Tuesday, Thursday, and then list B students do the opposite schedule. So there were a lot of questions about, what does it mean for a school to be closed in order for my employee to qualify for emergency family medical leave? And so what the Department of Labor said on June 26 is, in those 3 scenarios that I just described, the only one where a school is considered not closed is where the school gives parents the choice. you can send your child to school, or you can have your child attend remotely, and the parent, who is your employee, chooses to have their child attend remotely, then that employee would not be eligible for the emergency family medical leave because it was their choice. School technically is open. They're just choosing to not send their child to school. And the last bullet also, please double check with your state department or agency, whichever department administers UIB unemployment insurance benefits. States that are receiving federal funds under the FFCRA are required to tell employers to give their employees certain unemployment insurance benefit notices. And so the states are developing those. And so if that's not ringing a bell, again, talk with your company's employment council, or you can probably just go on your state, and they all have different names, but your state's Department of Labor, whatever agency administers unemployment insurance benefits, and see if there's a notice related to unemployment insurance that you're required to give your employees. Then you can see more updates here. IRS issues guidance about what do we have at the end of the year when you're generating your W-2s for employees that received any paid sick leave under the FFCRA, whether it was the emergency paid sick leave or the emergency family medical leave, what information you have to put on the W-2 and where. So again, your accountant's going to want that. I suspect they already have it, but just in case. That temporary I-9 rule about seeing the documents remotely, we can cut to the chase. It's been extended at least 3, if not 4 times. It's now extended through November the 19th, I believe is the date. And then in July, if you have questions about wage and hour, how do I pay an employee who's taking intermittent COVID-19 related leave, any wage and hour questions, that first link you see webpage under July 20th, FFCRA and FLSA, which is the Fair Labor Standards Act. There's FAQs about wage and hour issues related to the FFCRA. Next one, if you're an FMLA covered employer, again, you have 50 or more employees, 20 or more weeks in this or the preceding calendar year, you can click on that link and there's questions specific to Family Medical Leave Administration. And then that last bullet is the link, what I talked about before about when the CDC modified their recommendations about discontinuing home isolation. Then we're in August, and just generally speaking, I started to see more of a trend perhaps in states that were requiring face coverings, employers to provide face coverings. Some states have enacted a law that have a presumption of, if you have an employee who tests positive for COVID-19, there may be a presumption that the employee got it at work. Now, some states are pushing back very, very hard, saying that's not reasonable. Most of them are rebuttable presumptions, which means you have the opportunity to say, no way, I heard they were at a cookout last weekend. But the fact that you would have to go through that process, so just see if that, if your state is one that has added any of those presumptions. I would also, related to that, practical tip, you may want to call your workers' comp carrier if you're not self-insured and just ask them, hey, you know, it strikes me, I wanted to ask you, do you have any recommendations for what you recommend? What should we do to help ensure our employees aren't exposed to COVID-19 in the workplace? If they are, is there anything you want us to do? One, I think your workers' comp carrier would appreciate you asking that question. I don't know if it would reduce your premiums, but it might certainly reduce the risk. I think, again, it goes to that issue of demonstrating there's no way we were negligent. You know, we followed federal guidance. We called our workers' comp carrier. We're doing, you know, look at all these things that we're doing. Virginia recently became the very first state with mandatory rules for employers. They have to have basically preventive, corrective, and safety plans in place related to COVID-19. I have culled through those regulations. I was on a Maryland Chamber of Commerce call yesterday because Maryland is considering doing the same. And just listening to the employers from Virginia saying, oh my, you know, it's just a half-inch thick guidance of all the things, the records we have to keep, the training we have to do, we have to develop training programs. It can be very, very burdensome. So if you employ employees in Virginia and you haven't heard about that, you want to get up to speed on that sooner rather than later. Then we're moving closer to the present. August the 3rd is when I mentioned the judge, New York federal judge, ruled that 4 provisions of the FFCRA regulations that the Department of Labor put out were invalid. And I'm going to do these just real quickly, little nutshell version. This one just kind of blew my mind. So the judge said, the Department of Labor's regulations said to be eligible for paid leave, you have to be absent from work. Makes sense, right? You need leave from work. And so that means work has to be available for you. For example, if you're furloughed and then you happen to be tested positive for COVID-19, you have to take care of somebody, your child's school is closed, you're not eligible for the leave because you're furloughed. There's no work available, so you're not absent from work. The New York judge said, no, you could be furloughed and still get, still qualify for FFCRA leave if you have a qualifying reason. That's what the judge said. If you're panicking right now, catch your breath, because I have good news in a few minutes. Definition of healthcare provider. You may have heard there was a big hoorah. The Department of Labor, I will say their definition of healthcare provider is not applicable for you all, so we won't get into the weeds on this. But they basically said an employee, not the employer, an employee who is the healthcare provider is not eligible for FFCRA leave. They defined that very, very broadly and was pretty much any employee that works for a company that provides healthcare services. And so the judge said, wow, that's way too broad. I think he gave a good example. An English professor or a cafeteria manager who work at a university, but the university happens to have, like University of Maryland, they have the university, the school, the academic institution, but they're also affiliated with the University of Maryland medical system. And so the judge said, no, you have an English professor who teaches in the university, but he can't get FFCRA leave, or she can't, because they work for, a healthcare provider. That doesn't make sense. So the judge said, no, that's out. Intermittent leave. Question if an employee needs leave for reason number 5 under the FFCRA, which is my child's school is closed or my child's daycare provider is closed due to COVID-19. The Department of Labor regulation said the employee could take that leave intermittently, like I only need off Monday, Wednesday, Friday mornings and Tuesday, Thursday afternoons. Department of Labor said if the employer and employee agree, then that's fine. Judge said, no, employee has the right to do that at the employee's discretion. Don't panic on that one. And then documentation requirements, the judge said the Department of Labor's language wasn't right on point because it kind of read as if the employer could deny FFCRA leave until an employee provided the doctor's note. And the judge said, no, that's the employee gets the leave. Now, if they can't produce the note, then we know retroactively the leave wouldn't qualify, but you can't tell them they can't take off work until they get the doctor's note. So I'm going to tell you where, when we get to September, what the new rule in a nutshell says. A couple more updates in August. If I'm going really fast, I feel like I am, and I'm just keeping an eye on the time. I want to make sure we wrap up timely. Again, this I-9 rule about seeing the documents remotely was extended through September, and I already told you we already got another extension through November the 19th. This one, interesting. Remember I said there was that link you can click if you have wage and hour questions. August the 24th, Department of Labor issued specific guidance about how are we supposed to track time for our employees who are now working remotely. You know, this is new to us. They could be working at midnight. They could be working at 9. I didn't authorize that. So, Taryn, if you would, open up the second polling question. What do y'all think? Must an employer pay an employee who works unauthorized time from home? And I'm talking only about hourly employees, those who are non-exempt. that is eligible for minimum wage and overtime. Must an employer pay an employee who works unauthorized time from home? Yes, no, or it depends. What do you think? So answers are coming in. We don't quite have 50% participation yet. Oh, there we go. Now we're over 50.
I think this group knows you pretty well.
Well, that's called a clue. We actually have a tie. We have answers all across the board. We have a tie for 2 of the answers. I won't tell you quite yet. I don't want to sway your opinion. And we have 59% of you have participated. It doesn't look like any answers are coming in. So we can go ahead. I'm going to prepare to close out that poll. Right now, 17% of you said yes, you must pay. 39% of you said no, you do not have to pay. And plus 43% of you said, yeah, it depends, which, as Taryn pointed out, that is my favorite answer. And I would say, whatever you picked, you got it right. And so here's, I think that's coming up next, the guidance on that one. Bear with me. I'm going to take a peek ahead. Okay, let me tell you what that guidance is. And I didn't put it in the slide. So basically, what the Department of Labor, and again, you can click on guidance and get the full bulletin that came out. And I find this guidance is not new. It's kind of always been the rule, and I think it's a great refresher. You have to pay for time that employee works that you knew about or should have reasonably known about. And so if an employee is working and you have timekeeping procedures, hey, employees, you're required to record any and all time that you work, whether it's authorized or not. Here's how you record the time. Here's when you record the time. And then the employee doesn't record the time. Department of Labor says, we're not sure it's reasonable that you should have known that was worked. So if, next month or 6 months later, the employee files an FLSA claim and says, I wasn't paid for time worked. And you're able to say, here's our time record keeping policy and procedure. You didn't follow the procedure. You never told me you worked the time. I don't see any productivity during that period of time. How was I supposed to know you didn't tell us? Then the answer is, you might not have to pay for that time. So tips here. Provide a reasonable reporting procedure for non-scheduled time, and then compensate your employees for all reported hours of work, even hours that you didn't request. So yeah, if they report it, you have to pay them for it. But could you coach, counsel, issue corrective action? Absolutely yes. I think as a conversation, the first time is, I've got a budget. I need you to help me stay on the budget. You may not work any unauthorized time. And if you do it again, because, that's going to blow my budget, if you do it again, it might result in corrective action. And so that's, I think, how you balance those. Don't prevent or discourage employees from accurately reporting unscheduled time, because that's, that chilling effect. You don't want the employee to be able to say 6 months later when they file a claim, yeah, I know I didn't record my time, and let me tell you why. Because my supervisor said, if you work any unauthorized overtime and record it, I'm going to write you up. There's 2 different messages there. Don't work it. If you work it, you need to record it. And then we'll have another conversation about you're not supposed to work it. So interim regulations, this goes back. Remember the first polling question I said, hold that thought, because we're going to come back to it, about an employee who is asymptomatic. And so there you see under CDC, that first bullet, may that employee, and this is for critical infrastructure, so manufacturing, can that employee continue to work? And so guidance says they may be permitted to continue to work following potential exposure to COVID, provided they remain asymptomatic and the following precautions are used. And so you have this on the slide. I'm not going to read it to you, but you then need to pre-screen the employee, encourage the employee. They need to monitor themselves, make sure they're wearing a face covering, social distance. And I have 2 comments there. Semantics, right? Here's a tip. You can think about it. Mask versus face covering. I would suggest or recommend, talk to your company's legal counsel. As you issue these policies and procedures, I would use the word that's in your governor's executive order. Ours, for example, in Maryland, talks about face covering. You know, employees don't have to wear masks, they have to wear face covering, and our governor has defined what's a face covering. So little food for thought there. Do you call it a mask? Do you call it a face covering? I would use the language that is in your governor's executive order. Is it social distancing or physical distancing? As employers, I would use the word physical distancing, because this, you know, we don't want to lose the human aspect. It's not the social piece. Be as social as you like. It's the physical aspect. And I think that may help employees kind of keep that in mind. And then disinfection as well. Oops, there we go. September, 9 minutes left. So what happened this Wednesday? So August 3rd, judge says, Department of Labor, you exceeded your authority on these 4 issues. Remember what I just talked about? So is Department of Labor going to appeal? Apparently not, because this Wednesday, Department of Labor published revised regulations, and they agreed with the judge on 2 parts. They disagreed with the judge on 2 parts. And I felt so validated because it was the 2 that I thought were a little funky from the judge. So on the issue of documentation, Department of Labor said, okay, we're just going to clarify. We agree. You can't delay the leave until the employee gives you the doctor's note. But, so employee goes out on leave, but they still have to provide the doctor's note. And, okay, we agree. Maybe our definition of a healthcare provider that's not eligible as an employee for the paid leave probably was too broad, so they've narrowed that definition. Department of Labor did not agree with the judge on the intermittent leave issue. Department of Labor is sticking to its guns and saying, nope, if an employee's out for reason number 5, employee's child's school is closed, daycare is not available for a COVID-19 related reason, the employer and the employee still have to agree. Now, I will tell you the Department of Labor has this funky little exception in there. And again, I don't want to get in the weeds too far. Generally speaking, the employer and the employee would have to agree. And you can read a little bit more about that. And Department of Labor also did not agree with the judge that a furloughed employee, an employee for whom I don't have any work, I don't have work for you here because the station's closed, the department's closed, the unit's closed, the facility's closed, I don't have any work for you remotely, then that employee is not eligible for FFCRA leave if there's no work available. So stay tuned. I can't say that's going to be the end of it, because my question is, when's the next lawsuit? I anticipate we might see somebody say, well, I was furloughed. I think I should be eligible for leave. I think a more likely challenge might come on this intermittent leave. My employer said I couldn't take the leave intermittently. Here was my situation. I think I should. So I don't know. We'll stay tuned. Other question, I've gotten this question from others a couple of times. I don't have a crystal ball. I haven't heard anything. Will the FFCRA leave be extended beyond December 1st? I have no idea. I haven't, for the lobbyists on Capitol Hill that get involved in employment issues, I haven't even heard from them that they're hearing any rumors about that. So I think time will tell as we get closer to the end of the year. And then link here, you can click on this. I did find this article specific to the manufacturing industry about what's the projected impacts. Maybe some good news, maybe you're already experiencing this, some good, not so good. There might be an increase in local manufacturing, right? Supply chain has slowed. So maybe some businesses are saying, I can't get it from Iowa or, here I am, Mid-Atlantic region. Maybe I'm going to look more to my local manufacturers than I am those further away. Increased digitization, technology, skills training, that is new skills, and ramping up skills that employees may have, but they kind of need to refresh those, if you will. And consumer behavior, I think, is driving some of those modifications. What people are buying, when they're buying it, where they're buying it. Companies are doing, for you all, I think, this is my guess, a lot more shipping, right? I don't want to go to the store. I'm going to have somebody ship this stuff to me. Might require more boxes. And so that might be advantageous in your industry. And one more guidance here, you have the link, COVID-19 guidance for the manufacturing industry workforce. So I wanted to share that link with you as well. If you want more information about the Department of Labor's, I just kind of gave you the nutshell version where the Department of Labor agreed with the judge on 2 points, not 2 others. I am hosting a free webcast next Wednesday at 3 o'clock. You can click on that link. There's only 50 of 2, as of this morning, 50 of 200 seats left. So I don't know if that's going to fill up or not, but you're welcome to join that. And now I'm going to be quiet and turn it back over to Mike and Taryn for any questions, comments, etc.
Thank you, Christine.
Really appreciate that. Before we turn it over to questions, I want to raise a couple of issues that came to my mind while you were putting on this wonderful presentation. The AICC COVID Weekly Update page has as its first bullet point a link to a National Association of Manufacturers site that gives a state-by-state reference to the latest COVID regulations. So you've always got that path to check on what's going on in your state, as Christina suggested. AICC under the white paper section, and it is for members free of charge, has a business interruption agreement template such that if you lose a machine center or you have to take the plant down because COVID is in the plant and you've got to change your operations, we've got a David Goach reviewed document that can allow you to work with another member to make sure that your customers' orders are fulfilled. And the final thing is, I believe, Christine, 12 states are now offering liability protection for manufacturers that do have cases of COVID in the event that, I forget which state you had mentioned, which jumped to the conclusion that it must have been contracted on the job. Certain states are offering liability protection. At the COVID Weekly Update page, the week of September 7th, there is an article that links to those 12 states. So,
excellent. Thank you.
Steve, do you want to pick up the questioning?
Sure, thanks. And this really kind of is in 2 parts. Christine, on your slide where your first poll question, you asked if an employee is exposed to COVID, may he return to work? Or I'm paraphrasing. And you asked what the reaction was. So my question is, does an exposure automatically assume a positive test? Because I can be exposed to it, but not necessarily have it.
Right. So so if your question is, does an exposure assume a positive test? I think the answer is no. And so what's an analogy? If an employee has symptoms, that doesn't assume a positive test. I could have the regular flu, I could have a cold, I could have whatever. So the question is, if an employee has been exposed and or has symptoms, a lot of times we want to send the employee home and either we can require that employee be tested, and we need your negative test result before you can come back to work.
Right, okay.
And if you want the employee to stay, now we have guidance that says, okay, they actually could stay in the workplace so long as they stay asymptomatic. So my example of a symptomatic person wouldn't work, but yours would be fine, absolutely.
Okay.
Assuming those other, let me go back here. There we go. We follow those guidances.
So then in that case, then, if someone were to be exposed and they do return, can you identify that person to the rest of the employees?
No. So you could say, hey, gang, an employee, well, even in that case, I'm not sure, that's a good question. So what would we be obligated to tell coworkers that employee may have had an exposure? That's a really good question, and I would want to ponder that some more, because, so I'm thinking out loud, even if we said that, what are we going to tell our employees to do? I think they should do everything that we hopefully have been telling them to do all along. Self-monitor, physical distance, face covering, 6 feet apart. I'm not sure we would tell them to do anything else except, oh, now you can be even more nervous than maybe you were before because somebody in here might have been exposed. We don't know. So I think that's where you as the employer are going to decide, even though we're permitted to let that person continue to work, we might also want to say, tell you what, go to, you know, MediClinic down the road, get a test, stay home until you get the test result before you come back.
Steve, before you go forward, if anybody has any questions, you can post them in the chat feature, or you can raise your hand. If you're on the phone, you can press *9 and that will raise your hand as well.
I'm not seeing any more questions in the chat box, Taryn.
Christine, what about, you know, we're coming up on flu season, and there's no vaccine for COVID yet, but there is a vaccine for flu season. What can employers require vaccines of employees?
So a qualified, yes. EEOC permits, so Equal Employment Opportunity Commission permits employers to have mandatory flu vaccine requirements. Caveat, if an employee objects, and this is generally the healthcare industry, but it could be any, if the employee objects, no, I'm not doing it and you can't make me, we just need to ask some questions. And if the employee's objection is based on a medical reason that might be related to a disability under the ADA, Americans with Disabilities Act, so we might have to provide reasonable accommodation, that is, make an exception. Or if the employee objects for religious reasons, we might have to provide an accommodation under Title VII of the Civil Rights Act. There are also some states that mandate the flu vaccine, mostly again in the healthcare industry. There are also some states that have a law that permits an employee to refuse or object to the vaccine, and then kind of lays out, well, what are the employee's protections in that instance? So that's really, I think, state law question is know the law of your state, and if employees, Massachusetts is an example, because I just looked at this the other day. So employee in Massachusetts has the right to say, I'm not getting a flu vaccine and you can't make me, but then there are some steps that are followed of what that employee and employer can and cannot do.
Thank you. Mike, did you have something?
Well, Christine has provided a lot of information, and in case you didn't see it, the link to download the presentation, the PDF, Virginia posted it in the chat box. So before you exit, if you haven't already, you should scroll back up in the chat box and you'll find the link to the PDF so that you've got all of those hot links that exist in Christine's presentation.
Christine, another question. So can an employer just post a suggestion for flu shots?
Sure. I haven't come across anything that says an employer can't post the suggestion. You wash your hands, get a flu shot, 6 feet, yes, 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 yes.
Okay.
I think that's it. With right on time. Do you want to close it out, Mike?
Absolutely. I want to thank Christine once again. It's a tremendous amount of information, but I think it's all necessary to have, and we're glad that you've shared it with us. AICC will continue to provide the weekly updates at the webpage, as I mentioned, and we will continue to provide relevant and timely programming for all of our members. If anyone has any questions or has any difficulty getting the presentation today, just let Taryn or myself know via email, and we'll be sure to get it for you. I want to thank everybody for taking some time with us today, and we look forward to seeing you again on another AICC event, virtually, of course. Be on the lookout for a survey, speaking of virtual events, on travel preferences looking into the future as AICC plans and plots for what we hope to be in-person events in the future. Thanks, everybody. Have a wonderful Friday and a wonderful weekend.
Thank you. Be well. Stay safe.
Thank you,
Thanks,
Christine.
Thanks.
Christine. Bye-bye.